that are not supervised?
There have been concerns in the past with temper and just follow through. So I just want to ensure the safety and consistency of the visits.
Enjoy the video, hit the like button.
Or do you both swear the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Yes,
All right. Mr. Tatum, go ahead.
Your Honor, the state is requesting that the court take note that both parties are present before the court and both parties have received the amended petition and are requesting to proceed with this matter today.
So noted.
Thank you, Your Honor. At this time, Your Honor, the parties have a partial agreement, so the state is requesting to read into the record what has been agreed to by the parties. The parties agree that there's been no issues relating to family violence between the parties within the last 2 years. There's no request for non-disclosure, and the parties agree to a geographical restriction to Dallas and the surrounding counties. I believe that is the extent of the agreement. So at this time, Your Honor, the state would like to call the mother here in this matter. Ma'am, can I get you to state your name for the record?
yes, Bethany Draper,
And the name of the child or children that we're here in reference to? And the name of the child's father?
Robert Mays Jr.
And did you hear what I previously read into the record that was agreed to by the parties?
Yes,
And again, only in reference to what was agreed to by the parties, are you still currently in agreement with those terms?
yes,
Are you requesting the court accept those agreements and make them part of the order today?
yes.
And as it relates to the issue of conservatorship, are you requesting that you be named as the sole managing conservator for the child here in this matter?
Yes.
Is there any specific reason why you believe that you and the other party should not be named as joint managing conservators?
At this time, just due to the extended period of absence, I just want to ensure the stability and safety for my son.
All right. In the past, have you and the other party been able to work together to make decisions that are in the child's best interest?
Not thus far.
Okay. And do you believe that you being named as the sole managing conservator would be in your child's best interest?
Yes.
All right. And as it relates to the child, how does the child currently receive insurance? Is it through the state or through a outside insurance?
So he currently has Medicaid, and then we were on his father's insurance.
And has that insurance stopped?
At this point, I'm not sure. To my knowledge, it had not, but I just received updated information, so I'm not sure if it's out or not now.
All right. And is it your understanding that the father in this matter is currently unemployed?
That is to my recent knowledge today, yes.
All right. The state has used the father's reported unemployment benefits for the calculation of support based on the weekly benefit amount of $591 and will request that the father pays child support in the amount of $401 per month. Are you in agreement to that amount?
Yes.
And as it relates to the insurance, the state has calculated that the father should pay $230 for state medical. Are you in agreement to that amount?
Yes.
And you are requesting that the child remains on state medical, is that correct?
Yes, at least until I get back to work.
All right. And as it relates to visitation, has the father had any visits with the child here recently?
Not since February 21st, 2025.
Is there any specific reason why the father hasn't had any visitation since February?
Not to my knowledge, besides not being able to agree on visitation.
All right. And are you requesting that the father has 12 warm-up visits prior to moving into a standard possession order?
Yes.
Are you requesting that the warm-up visits will be on the first and third Saturday from 1 to 4 to be supervised by the paternal grandmother?
Yes, unless his schedule permits more wiggle room.
All right. And as it relates to the additional 6 visits, are you requesting that they take place on the first and third Saturday from 10 a.m. to 4 p.m., again, to be supervised by the paternal grandmother?
Yes.
Is there any specific reason why you believe that the grandmother shall supervise the visitation?
Just from knowing her over the years, she seems level-headed and will hold us accountable.
All right. Is there any specific reason why the father should not have visitations that are not supervised?
There have been concerns in the past with temper and just follow through. So I just want to ensure the safety and consistency of the visits for our son.
All right, and are you requesting retroactive support for the past 12 months?
Yes.
And as it relates to that retroactive support request, has the father given you any support over the past 12 months for the child?
February, March, and April, he gave me $200 per month, 600 in total, and that is the only support I have received.
All right, given credit for $600, the state will request a judgment in the amount of $4,212 to be paid at $50 per month. Are you in agreement to that amount?
Yes.
And do you agree for the father to pay the court costs associated with today's hearing?
Yes.
Do you have any additional information that you'd like to offer to the court as it relates to this matter?
Currently, our son has a lot of belongings that are still at his father's. I just like to request that that be released for our son.
And ma'am, do you understand that that issue that you just spoke of is not properly before the court today, as there's been nothing filed with the court to address that?
Okay, that's fine. Yes.
Nothing further from this party owner. At this time, your owner of the state would like to call the party Mr. Mays. Mr. Mays, can I get you to state your name for the record?
Robert Mays Jr.
And Mr. Mays, did you hear what I previously read into the record that was agreed to by the parties?
Yes.
And only in reference to those agreements, sir, are you still currently in agreement to those terms only?
Yes.
Are you requesting that the court accept those agreements and make them part of the order today?
Yes.
And sir, are you currently employed?
I'm not.
All right, the state has used your unemployment benefits for the calculation of support today and would request that you pay child support in the amount of $401 per month with no additional credits. Are you in agreement to that amount, sir?
No.
Could you explain to the court why you don't agree to paying support based off of your current income?
I don't believe that I should pay that due to the fact that I am here, I am available.
I'm sorry, sir, you're breaking
not
up. I
employed
can't hear you. Could you repeat your answer, sir?
any fatherly duties. I was at the hospital, drove away from the hospital after we drove to the hospital together when he was born. I signed the birth certificate. We left the hospital together. We lived together. I've been here. I've tried to ask her to see our son
We're
several
just talking
times.
about
I
future
was
child
told I'm
support,
only
sir.
able to see him.
Sir, we're just talking about future child
Oh
support
yes.
beginning in January. I'm not asking it. He
Oh,
didn't ask
I'm
you
so
anything about
sorry.
the past.
I'm sorry about that.
So his question was, why do you not agree to the 401 for the future?
When we did at the place that I live, our rent was $2,200, which is a place that we both agreed to, along with, of course, my other bills that I do have to pay, and just me not, or me being on unemployment at this time. I don't think um, I'm not in agreement with that.
So just to confirm, so you're stating that you believe the amount that's being requested is too high, is that correct?
Yes, sir.
All right. Other than your belief that the amount is too high, is there any other specific reason why the child support should not be set based off the guideline amount?
Um, no, not other. No, I don't believe so. No.
All right. So as it relates to the issue of medical support, the state is requesting that you pay state medical in the amount of $230 per month. Are you in agreement to that amount?
No.
And could you explain to the court why you don't agree to paying medical support in the amount of $230 per month?
And again, just with my rent being 2,200, my car note, my insurance, my lights, everything, that's just a high number that to me just I'm not able to.
And sir, do you understand that the
So,
state in calculation support does not give credit for any of your bills? It's strictly based off of your current income to calculate the support.
okay, yeah, I'm not sure. I'm trying to I'm doing the best that I can, sir.
All
So
right. As
to
it
answer
relates,
these questions,
all right, thank you, sir. As it relates to the issue of conservatorship, are you in agreement to the mother's request for her to be named as the sole managing conservator for the child here in this matter?
no,
All right, you're requesting that the parties be named as joint managing conservators, is that correct?
yes, sir.
And in the past, sir, have you and the other party been able to make decisions together that are in the child's best interest?
We have not.
However, you believe that in the future you two will be able to do it. Is that correct?
From past, I doesn't seem as if that'll be possible.
So you
I
believe
was
that the
told
parties
that we
would not
weren't
be
able to agree with them unless we had a court order.
all right. So just to confirm, so you're stating that you don't believe that the parties will be able to make decisions together in the child's best interest. However, you want the parties to be named as joint managing conservators instead of the mother being the one who primarily make decisions.
Yeah, I mean, it's not due to me not wanting to. It's just that what she's asking me to do is unreasonable and unfair, and I don't understand why. I've not done anything or to her or our son in order to permit that I'm angry or I've done anything. I was feeding them up at 1, 2, 3 o'clock, all that. So I don't understand why she decided to up and leave, and now we're here. And I was told the only reason or way I can see him is going to her mom's house or if we had a court order. So we're in court right now.
All right. And as it relates to visitation, sir, the mother is requesting that you have 12 warm-up visits. Are you in agreement to the warm-up visits prior to the parties moving forward to a standard possession order?
No, sir. I would like to see my son today, if that's possible. It's been 10 months. I don't know if he has teeth, if he's crawling, walk. I don't know anything, what he looks like. So I would like to see him today or as soon as possible.
And when was the last time you had any visitation with the child, sir?
February 21st, 2025.
And what actions have you attempted to do to get visitation with the child since February?
I have reached out to her. I've asked to meet other than her mom's house. I have asked to have my child for some time to get to know him, to be with him, other than going to her mom's house. And the only thing that I was told is that I can only go to her mom's house with her mom and sister there, or wait until we have a court order. There was no other leeway or anything in there, and I just don't understand why, because I haven't done anything to her or our son or in to for that to be the case.
All right, thank you, sir. And the mother is requesting retroactive support for the past 12 months, giving a credit of $600, thus requesting a judgment in the amount of $4,212 to be paid at $50 per month. Are you in agreement to this request, sir?
No,
In the past 12 months, how much money, if any, would you say that you have provided to the mother directly for the support of the child?
excuse me. February, March, and April, I did send $200 each month. Along with, I did drop off some Pampers, diapers, wipes, and things like that at her mom's house, which I didn't take any picture or anything, but she did send me a thank you, which means she received it.
All right, so just to confirm, sir, as it relates to direct payments, you are in agreement that you have provided the mother with $600 within the past 12 months for the support of the child. Again, that's direct payments. Is that correct?
Yes, sir.
All right. Nothing further from this party owner.
All right. I'm making a finding there's been no family violence. We're establishing paternity that Mr. Mays is the biological father. If we're having problems with communication, then I'm going to appoint the mother as a sole managing conservator for her to make decisions regarding the child. We don't have any private health insurance at this time, so the court's going to read that mother will apply for government health care. The medical support, I'm going to reduce it from the $230 those requested to $200 per month. If either one of you find insurance in the future, then you can do that instead. If Mr. Mays, you carry the insurance in the future, you need to get a copy of the card to the mother and to the AG's office and the Medicaid office, and then you could just pay for your premium and not have to pay this additional $200 a month. Child support is appropriate at $401. I could not take into account either one of your expenses. Ms. Draper's has expenses as well. You both have expenses. I mean, that's the way it is. I cannot lower your support because you have expenses or because of you're still trying to deal with the separation. I can't do much about that. I can't lower your support for that reason. I'm not finding a reason for there to be supervised visits. There's a relationship with the child and the father. The child's old enough to know who their father is. You haven't proven to me that there should be a reason for there to be supervised visits. So I find that Mr. May should have standard visitation with his child, which is Friday, first, third, and fifth Fridays of each month at 6 o'clock until Sunday at 6 o'clock every other weekend. This is the first Friday of this month, so tomorrow basically. Mr. Mays has a right to pick up the child at 6 o'clock at your residence, Ms. Draper, and then he'll bring the child back on Sunday at 6. And then also every Thursday night, regardless of whether it's your visitation week or not, you have the right to visit for 2 hours from 6 to 8 every week. And then holidays are also split up in the court order that y'all need to read. I don't find reason for there to be supervised visits. We need to visit. Your issues you have met with each other have nothing to do with your child. And if we have to do a court order to make the visits official, then that is what we're going to do. And y'all must follow it even if you don't agree. The child must follow it even if they don't agree. There has to be visitation. So we're doing a standard visitation order with no supervision. On the retroactive support, the amount requested was 4,212. I'm just going to round that to 4,000. So if there was anything else that was paid for, that'll be included in there. So there's judgment for $4,000 for back child support, payable at $40 a month instead of $50 a month, and court calls as billed to Mr. Mays. The Attorney General's office will draft an order for me to sign to make that official. I'm not sure if you'll get that by tomorrow. But that, that's the order of the court that you must follow, even if you don't agree. So just make sure, at least for this week, if you don't get an order, it's Friday at 6. Tomorrow at 6 o'clock, Mr. Bay is going to come to your residence at your door, not inside, just at the door. You're to release the child to him. He's bringing the child on Sunday at 6. The child cries or whatever, that's not a reason to deny visitation. So just make sure we follow those rules, and then you should have an order by the next time we have a visitation coming up. All right. Anything else, Mr. Tatum?
Nothing further from the state, Your Honor.
Okay. All right, then. Hopefully they can get that to you tomorrow, but just understand that's what we're doing here. Yes, Mr. Mays?
Excuse me, I'm sorry. Am I able to appeal?
You can always appeal my decision, but that doesn't mean that just because you file an appeal doesn't mean that it's overturned immediately.
Okay.
I've done everything as fair as I could, Mr. Mays. It could be worse. So just understand that too. But I mean, based on what I heard from both of you, that's pretty fair, I think, for both sides. The no court's going to take into account your expenses, no court. So that's not going to happen. But yeah, you can appeal me if you want, but the order still stands until you get convince a different judge to do something different. All right, y'all are done with court today. You can press leave on the Zoom to exit out. Thank you.